base in Japan for that, and an air base actually in Japan too. Any jurisdiction has to be worked out between the United States and Japan. Okay, I just wanted to make sure we were still rolling there. Okay, good. All right, so what we're going to do now is talk about doctrines in international law. Now, is it true we can have conflicts? Absolutely. So the question becomes, how do we try to plow through some of these conflicts in international law, especially in regard to jurisdiction, okay? Now, we're only going to look at three, but these would be the three big ones, right, to determine how we might best determine where jurisdiction should rest, right? More specifically with which country. Okay, now, the best way to look at these three doctrines is that we're going to screen out possibilities. So let's say we have, let's go back to that price fixing case, right? We had an Austrian firm, we had a Romanian firm, the activity was, the plotting, if you will, was taking place in Switzerland, and the goal was to affect prices here in the United States, right? Okay, now, in what country would it make sense? So we're going to use these doctrines to kind of sort through some issues. Okay, the first is comity, right? And comity is really based on efficiency. Where does it make sense to hold the case? All right, where does it make sense? Now, more narrowly, courts, under the principle of comity, right, are supposed to defer to the actions of courts in other countries. Okay? So in other words, under comity, right, American courts should acknowledge the judicial decisions of, say, Sweden, right? Or Spain, or what have you, and say, you know what, that's enough. There was one case, we're going to adhere to it. So let's look at a particular example whereby we have a seller and a buyer. Seller is in Sweden, buyer is in the United States. Let's say it's a breach of contract case. Seller sues buyer in Sweden, right? Probably wanting the home court advantage, if you will. All right? And let's say the Swedish courts fine for the Swedish buyer. Well, most likely what's going to happen is the American courts will say, okay, case closed, right? And the buyer might say, no, wait a minute, I want my day in court in the United States. And an American court will say, well, if it was fair and the law is not too different from ours, right? When we're going to adhere to that judicial opinion. Now you might ask, well, why is that a big deal? Okay, well, what happens if to satisfy that judgment by the Swedish court, the buyer has assets in Sweden? Well, what will take place is that the Swedish court, just like it would take place here, by the way, the Swedish court would order its law enforcement to liquidate the assets of the buyer and give those assets to the seller. Okay, now that's what makes, by the way, just to kind of turn it around a little bit, what makes American courts so attractive, because there are so many assets sitting in American banks. So when you do engage in litigation in the United States, well, the assets are there too. And American courts, be they state courts or federal courts, would certainly just tell law enforcement, the appropriate law enforcement body, be it again federal or state, to go ahead and liquidate the assets and make sure that the judgment is satisfied. Okay, act of state is a little bit different. Comity deals with judicial opinions. Act of state deals with executive actions, right? So in the United States, that would be actions of our executive branch, the president. In some countries, it's the chancellor. In some countries, it is the prime minister. Okay, now, let's take a look. We can go ahead and get rid of this map, right? Okay, all right. What we're going to do is we're going to look at two actions by executive branches that cause a lot of grief in international law, all right? The first is expropriation, right? Now, here a country seizes the assets of a foreign company but provides fair market value in return. Okay? So again, the executive branch, be it the president, chancellor, prime minister, seizes the assets, right, of a foreign company but provides fair market value for those assets. Okay, now, very important, expropriation is legal under international law. And I say it doesn't seem fair. Well, you could make that argument. Doesn't seem right, doesn't seem just, I get it. Okay, but it is lawful under an international law. So let's say, for instance, XYZ Corporation of the United States is doing business in Guatemala. And the Guatemalan government seizes the assets. Maybe it's a manufacturing plant. Maybe it's also a truck fleet, right, owned by XYZ Corporation. And in return, the Guatemalan government says, well, here's fair market value. We're done. Well, can XYZ Corporation sue the Guatemalan government in an American court? And the answer is no. Our courts will look at the act, expropriation, seizure of assets, manufacturing plant, truck fleet, whatever. Was there fair market value? Certainly debatable. But if that's the reality, all right, XYZ Corporation is not going to be able to sue Guatemala, the Guatemalan government, in an American court. Now, I will tell you this, they can sue Guatemala in a Guatemalan court. That they can do. But our courts are going to defer to the actions of the executive branch in Guatemala. Okay. Now, you might think, well, what's the point of suing Guatemala in a Guatemalan court? Well, maybe nothing. Okay. But that's why, again, the American courts will look at expropriation, the act itself, and whether fair market value was provided. Okay. And again, you can certainly debate the other. Okay, but the other is confiscation. Okay, now, confiscation, seizure of assets, no fair market value. All right, seizure of assets, no fair market value. Now, that does seem unfair, unjust, etc. And confiscation is illegal under international law. So let's go back to our example. Let's say XYZ Corporation has assets in Guatemala, right? And the Guatemalan government seizes those assets and doesn't provide fair market value. In such a case, then XYZ Corporation can sue the Guatemalan government in an American court. Now, can they also sue in a Guatemalan court? Sure, no problem. Just like with expropriation. But you might think, well, is that going to do you any good? Well, probably not. But can you sue in a confiscation case the Guatemalan government in an American court? And the answer is yes, because it's illegal under international law. It's not a justified act by an executive branch. Now, to put this into perspective, there are still outstanding claims from 1917 when the Russian government confiscated assets following its revolution, right? And these were companies all around the world. Same thing in Cuba in 1959. Okay, so again, there's a lot of litigation there. Now again, there's a lot of politics behind that too, but we're interested in just the law for right now. Okay, and lastly, sovereign immunity. Now, sovereign immunity is probably one of the most difficult concepts because it looks a little bit like comity, it looks a little bit like the Act of State doctrine, but it is separate. Okay, now, sovereign immunity has a blanket rule and then lots and lots and lots of exceptions. Okay, sovereign immunity basically says this, right? A country cannot be sued in another country's courts, right? So Venezuela as a country can't be sued in an American court. Okay, now there are many, many, many exceptions to that, and I'm going to give you the one that comes up most anyway, and that is for commercial activity. All right. Now, simply stated, when a country starts acting like a business, that means it's buying and selling goods from a company from another country, it waives sovereign immunity. Right? So let's say, for instance, we have a contract between an American seller of goods and the Venezuelan government. Who's buying those goods, right? The Venezuelan government is the buyer. Could be ABC Company here in the United States. All right? Buying and selling goods. And let's say the goods are sent to Venezuela. Venezuela, being a very impoverished country right now with almost no money, all right, doesn't pay the bill. What happens then? Well, at that point, ABC Corporation, remember the seller of the goods, selling the goods to the Venezuelan government, can sue the Venezuelan government in the United States courts. Now, again, can you sue the Venezuelan government in a Venezuelan court? Sure. Is it going to do much good? Probably not. All right. But nonetheless, you have that option. So again, sovereign immunity has this blanket rule. A country cannot be sued in another country's courts, but lots and lots and lots of exceptions. Right. And I'm just going to give you the one, but that's the one that kind of pops up most. Okay, and every country, by the way, has its own versions of sovereign immunity. So, okay, so those are just three ways, right? Three doctrines, if you will, that help us decide what's the best jurisdiction. But you notice they all kind of screen them out a little bit. Okay. All right. Now, let's go ahead and look at choice of law and choice of forum clauses in international contracts. Now, anybody who is serving as an attorney to an international party will recommend that both of these things be in the contract. Okay? Now, you probably realized at this point that contract law is very, very flexible, and especially even more flexible when it comes to contracts for the sale of goods, right? Okay. It's so flexible, you can choose what body of law will govern a dispute. And you can choose where, especially in a case that might have many countries that might have jurisdiction, where the case should be heard. Now, again, any attorney consulting an international client in a case like this will certainly say, yeah, you got to have these clauses. Okay, choice of law. Basically, you're dictating what body of law will apply to a breach case. All right? So before anything bad's happened, these two parties are negotiating the contract. They're going to negotiate what body of law will apply. Now, when it comes to a choice of law clause, it's much more flexible than its counterpart, the choice of forum. With a choice of law clause, you can use any body of law that you want. So, for instance, it could be a contract between a Greek seller and an Italian buyer, and they may say Portuguese law will prevail. That's fine. Right? They could choose Italian law? Sure. Could they choose Greek law? Sure. Could they choose the law of another country? Sure. Could it be a country from a different legal system? So let's say it's Italy, one party from Italy, one party from Greece, and they want to use Indian law, right? A common law country. Sure, they can certainly do that. Much more flexible. Now again, there is some strategy, and chances are the body of law chosen won't be too far from what it is that they generally do. Okay, but nonetheless, a lot of flexibility, and you should always have that in your contract. Okay, the second is the second type of clause we're talking about is the choice of forum clause. All right, this is where. Anytime you think you hear or think of forum, you're thinking about where. Okay, now where is much narrower. So if you go back to our contract between an Italian buyer and a Greek seller, right? It's got to be Italy or Greece, or someplace where the commercial activity is taking place. So let's say it's an Italian buyer, a Greek seller, and the transaction is taking place in Finland. Well, that gives you 3 countries anyway, but no more than 3. Okay? Now, is it likely that the parties will agree to a choice of law and a form that match? Sure. So let's go back to the Italian buyer, the Greek seller, and the activities taking place in Finland, and they say, well, the case should be heard in Finland. It probably makes sense that you're going to use Finnish law, right? Makes it easier for the courts, but again, you don't have to. If you want to use Venezuelan law, you can. But you're asking a Finnish court to apply Venezuelan law, and it might be somewhat challenging. Okay, but you really should have both those. Okay, now what we're going to do is jump and kind of switch gears and get into some mechanics. Now, this isn't raw law, if you will, but this is more so supply chain. I've had this as part of the course for quite some time. Supply chain is very, very important. This is kind of the hubbub when it comes to what you've read about NAFTA and possibly NAFTA breaking apart. Well, you've got all these companies that are saying, you know, you guys need to put your politics aside because we've already established the supply chain. So essentially what we're doing is we're talking about how to export and manufacture in another country. Okay, so what we're going to do is we're going to start with the idea that we have an American company making something here in the United States. All right, but we want to engage in international business, right? We want to engage in trade, right? Because it helps the company. It makes sense. Okay, so we're going to start with exporting techniques and essentially how we do this, how we send our goods we're making here in the United States somewhere else. Okay? All right, so let's start with direct exporting. Now, this is the easiest way to engage in exporting. You merely sell your goods to a foreign purchaser, right? So if we look at, or by the way, I should say, when we look at these 3 forms of exporting, what you're going to see is we're looking at 3 different parties, all right, as partners. Okay, so when it comes to direct exporting, right, you just merely sell your goods to a foreign purchaser, right? And it really doesn't matter how the goods get there, but you're just saying, here you go. Okay, now, the risk is minimal because you've already got your money. But the profit tends to be a little bit reduced as well. Okay, so I am kind of giving you some foreshadowing. The 2 forms of indirect exporting tend to give you higher profits, but again, a little bit more risk. Okay, so again, it doesn't matter how the goods get there, right? You're merely just selling them to a foreign purchaser. Okay, what about indirect exporting using a foreign agent? Okay, now what happens here is the American firm that's, again, making these goods here in the United States says, well, we're warming up a little bit. We're getting more used to international trade and international business. So we think we're going to take a little bit more control over our product and hire a foreign agent. All right? Now, what a foreign agent will do is take those goods and scout out places for them to be sold, new markets for them to be sold. And then, by the way, it doesn't have to be goods, it could be services, it could be all sorts of things. Okay? But a foreign agent is going to be given a geographic area, say Europe, and they're going to find the right places to sell your goods. Now, a little bit more risk because you haven't sold anything yet. But the profits tend to be a little bit higher on average, right? But you really have to know what you're doing. Now, the foreign agent, by the way, is going to be a consulting group, a consulting house, and they have expertise, and they've been doing this a long period of time. So there's a bidding process, and you pick the right ones. But some consulting firms may be much better in Western Europe than Eastern Europe, et cetera. So you want to find a foreign agent certainly with experience. But again, a little bit more risk because you haven't sold anything. right? When it's direct exporting, foreign purchaser, you sell it and you got your money, all right? But chances are the profits are going to be reduced. Okay, lastly, indirect exporting using a foreign distributor. Now, the company making goods here in the United States is so comfortable with international trade, international business, and they think they know their markets well enough, they already know, they don't need a foreign agent anymore, they already know where they're going to put those goods. So they merely hire a foreign distributor. Now, a foreign distributor is basically just a logistics firm. I mean, it's good work and it's smart work and it's hard work, all right? But all they're going to do is get the goods from port to store. All right? So they know roads, bridges, tolls, shipping, rails, pipelines, all that kind of stuff, all right? And they're going to get the goods from port to store. You've already decided where they're going to go. Now, greater risk? Absolutely, because you haven't sold a thing. But the profits tend to be a little bit greater. Okay? Now, one thing I want to stick in your head before we get into manufacturing abroad is that one of the biggest risks is not, I mean, one certainly is whether you get your money or not, whether you get paid, but one is always going to be intellectual property. Okay? When you send your goods somewhere else, you take some intellectual property risks, right? And more narrowly, theft of your patents, theft of your copyright, theft of your trademarks, and theft of your trade secrets, which is the fourth area of intellectual property some people forget, but very, very important. Okay, now what we're going to do is we're going to manufacture the goods. So we're so warmed up, we're so comfortable with international trade, we're going to move production elsewhere. Okay, now, there are many reasons as to why you would move your production elsewhere. Okay? One, maybe the labor's cheaper. Okay? What we're finding is that is certainly a reality. Okay? But you really do have to measure labor costs against transportation costs. So number two, one of the reasons why you might move manufacturing somewhere else is because that's where your customer base is. You're shrinking, right, the distance between you and your customer, and therefore reducing your transportation costs. Now, a classic example of that, by the way, is here, right, in the United States. If you think about a Mercedes-Benz that you drive, or if you drive one, or a BMW, chances are it was made right here in the United States. All right, a Kia made here, Toyota probably made here, Nissan probably made here. All right, now car companies admittedly are more so assemblers, and the parts are coming from all over the place. But firms have gotten smart. If Americans buy cars, and that's what they do, why don't you make it there? And although your labor costs might be higher, your distribution costs will be a lot less. All right, and cars are big things, and they're certainly expensive to move around. Okay, now, so those are two, but we're not done with our list as to why you're going to move it somewhere else, all right? Number three, you might be closer to raw materials. So if you are manufacturing goods that are highly dependent upon strategic materials, right? Could be lithium, like for phones or car batteries or what have you. You might want to do that close to the raw materials because that also reduces your transportation costs of getting the raw materials to your plant. Now, if it just so happens that's where your customers are too, then all the better. Okay. Now, lastly, all right, you might move your manufacturing because you have to. Okay? Maybe it's a country that says if you want to sell your goods here, you got to make it here. All right? Now, it's certainly related to getting closer to your customer base, but maybe that's the only way you get into that market. And maybe through a joint venture, and China is probably the classic example of that, where it's very, very hard to get into the Chinese market if you're not partnering with an existing Chinese company, because on that basis they want to know how you do business, right? They're learning. They're pretty good capitalists, right? Okay. Now let's think about how we can do this, all right? Number one, we can license our technology, and some other company is going to make it. Right? So we're going to have it made over there, but it's just not going to be by us. It's going to be by some company. And we're going to license the product, license the technology to that company who's going to make it. Okay? Maybe it's a company that's already established and they're already up and running and they're good at making whatever it is you want them to make. All right? Now, licensing works very, very well because you can make some good money without doing really hardly anything. You're just signing a contract saying you're going to pay me on a particular basis for making my product. Now, licensing is generally based on royalties, right? So the American company that's licensing the product and licensing the technology to the foreign company is going to make money through royalties. Now, most of the time, those royalties are based on a percentage of what is sold. Okay? However, we're seeing more and more contracts where the royalties are based on a percentage made, and largely to kind of adjust the economies of scale and scope to the point where you're not making too many of those things whereby, too many of the goods whereby the margins are getting squeezed. So sometimes it's better just to assess a percentage on what is actually produced. Now, when it comes to licensing, it doesn't have to be your traditional intellectual property. What you license doesn't have to be protected by patent, trademark, copyright, or the common law of trade secrets. It doesn't have to be. I mean, you can license non-patented, non-copyrighted, non-trademarked items. Now you might think, well, why would you do that? Well, a lot of times you have the first mover advantage and your product is so good, you just couldn't get a patent, a copyright, trademark, but it's so good, people want it, and you just go ahead and license it. Chances are the duration of that agreement would be very, very short. All right, so if you have intellectual property protection, the duration of your licensing agreement can be a little bit longer because you'll make a little bit more money, but doesn't mean you can't license stuff that's not protected through intellectual property law. Okay, now, something that I find fascinating is franchising. I absolutely do. I've been lucky enough to travel, and I find franchising fascinating. Now, I'll kind of maybe a weird reality, but I generally do not eat McDonald's here in the United States. But man, when I travel, if I see the Golden Arches, I got to have my McDonald's, right? Because I know what I'm gonna get. All right, I know what I'm going to get. All right, now franchising, right, allows for product standardization. So if you go in to a McDonald's in Belgium or Australia, you know that Big Mac's a Big Mac. You know that Quarter Pounder's a Quarter Pounder. You know what you're going to get. And sometimes when you're traveling and you're not quite sure what you want, and believe me, I love to eat and love to eat out and try new things. But if I'm in an area where I'm not really sure what it is I'm going to get, I'll probably pump the brakes a little bit, right? Okay, now, with that said, all right, you have a franchisor and a franchisee. The franchisor would be McDonald's International. The franchisee would be the person who's buying the franchise, right? And it could be a hotel, it could be rent-a-car, it could be Avis, Hertz, whatever. It could be anything, really. But again, there's going to be product standardization, franchisor, and a franchisee. Now, the franchisor sells the franchise to the franchisee, and the franchisor, say McDonald's International, is going to make money in three ways. All right, number one, there's a lump sum for the franchise. All right, so say $1.5 million to buy the franchise, the McDonald's franchise, that you're going to put, say, in Barcelona. Okay, number two, the supplier agreement. Now this is what creates the product standardization. So if you think about the McDonald's franchise you've purchased and you've put in Barcelona, any hamburger patty, French fries, ketchup, buns, whatever, you're going to also buy from McDonald's International. They're going to supply you with those foodstuffs. And why? Well, they simply want to make sure that that sandwich is the same wherever you go. Okay, so that's two. What about the third? A percentage of what's sold. Okay, so a percentage, maybe 1%, 2% of every Big Mac that's sold. All right. 1% of every coffee that's sold. Now, one of the things that franchisors have learned is you do want to create a little bit of flexibility with your franchisees, right? McDonald's International might not work in, say, Akron the way it works in Barcelona, right? Or Paris or wherever. Now, if you travel enough, what you're going to find is the greatest variety in regard to McDonald's is breakfast. The breakfast menus are always a little bit different, right? So, nonetheless, you want to create a little bit of flexibility, but for the most part, there is going to be an expectation of product standardization that's generally delivered through the supplier agreement. So again, any hamburger patties, ketchup, coffee, whatever you're going to get from McDonald's International. But again, for a franchisor, much like with licensing, it's an easy way to make money for not a whole lot of work. Now, there's always that responsibility to go ahead and visit those franchisees and make sure that they're adhering to what the contract requires. Okay, now, licensing, somebody else is making it. Franchising, somebody else is doing it. Foreign direct investment's a different ballgame. You're going there and you're going to make it. You're not licensing anything. You're not franchising anything. You are going to go there. Okay? Now, two ways to do this. Okay? You can take over an existing operation, an existing plant, if you will, or engage in fresh construction, new construction, if you will. Okay? Now, if I were teaching this class 30 years ago, 40 years ago, your best bet was really take over an existing operation, retool it, right? And then go from there. That's no longer the case. Fresh construction, brand new construction is really the way to go. Now, the reason for that is that foreign direct investment is competitive. Okay? You have all these countries that want your firm to come there. Right? Now again, you still have to worry about some of the same things we talked about at the beginning of this section on manufacturing overseas. You're looking at labor costs, where are your customers, right? Where are the raw materials? Is this the only way you're going to get into the country, right? There's entry restrictions, etc. But once you get past that, these countries will do a lot for you. Okay? They might give you tax breaks. They might even build the plant for you, or at least build the infrastructure up to the plant, right? Roads, lighting, electric, power, sewer, water, that kind of thing, okay? Now, in return, they want two things, right? So when you make a deal with this country for the tax breaks, the infrastructure, roads, what have you, they want two things. They're going to expect, number one, that you stay, all right? They don't want you leaving. They want you to stay, okay? And number two, they want you to employ their people. So they might tie you to an employment agreement that says 90% of your workers in this plant have to be from our country. So let's say you make a deal with the Ukrainian government, right? The Ukrainian government says you got to be here 10 years if you want this stuff. And 90% of your workers have to be Ukrainian. Okay? Now, generally, these agreements don't get into management, so it's not like 90% of the floor workers have to be Ukrainian, 90% of the managers. It's generally 90% of the total workforce has to be Ukrainian. Okay. So again, they want two things. Now, in the end, this becomes really a capital budgeting issue. So I know some of you are going to take the finance course. Some of you have already taken the finance course. But the decision is to whether to do it yourself. Go to another country and do it yourself. Whether you're taking over an existing plant or you're engaging in fresh construction, it's really a capital budgeting project. Will you